Thanks for everyone for joining us today. Obviously, we'll be discussing navigating the role of company directors. My name's Connor Spencer. If you've not dealt with me or spoken to me or seen me before, I'm one of the team leads for our legal and accounting solutions here at Lawpath. Um, the purpose of today's webinar is just to give a bit of a foundation understanding of what to be aware of when being a company director. We're also joined here by Damin Murdock. He's Lawpath's principal lawyer. Has a wealth of experience over 15 years. I don't know if actually you maybe want to introduce yourself, Damon, say a little bit about your background.
Sure. So today we are talking about company director duties, and it's quite relevant to me because I've just recently brought a couple Supreme Court proceedings recently on this topic, so it's in my mind at the moment. So I've been a solicitor for over 15 years. I practice in New South Wales, Victoria, and Queensland. And I've been in pretty much every court and tribunal across those three states. And I primarily work in commercial law and do a fair amount of litigation around the Corporations Act.
Yeah, nice. Thanks, Damon. Cool. So, if you actually are new to Lawpath, if you are coming across to us for the first time, we are an Australian-based online legal, accounting, and tax advice platform. We've been operating for 10 years now, and actually helped over close. Well, we've actually just surpassed the 500,000 small to medium businesses that we've registered in that time period. A little bit about what we do. We supply over 500 legal documents. These have all been drafted by commercial lawyers. They're up to date with Australian legislation, so a lot of the lawyers and accountants do use us, but most people using the platform for the advice or documents are startups, are small, medium business owners. Need to quickly jump in, grab these documents. They're fully customizable. Comes with a contract builder, so depending on what you're putting in on the input, we'll adapt the contracts and obviously provide you that legal floor specific to your business. And we provide a really unique subscription service. We've got close to 15,000 business owners actively using our subscriptions. And we're all just about providing simple solutions to complex legal and accounting issues. So you can understand your legal position, simplify the legal jargon, and always be engaging in good business practice. So we want you to be treating, especially if you're at the early phase or any phase of your business, as if it's going to potentially be the next Amazon or Apple. But if maybe that does sound maybe out of reach, at least make your business the absolute best it can be. And one part of that, amongst many others, is obviously ensuring your business is set up for success by fulfilling your legal obligations, and ensuring you're armed with quality accountants and tax agents to protect the financial health of your business. You might have seen I've just dropped into the general chat box. You can also hear that from other people by clicking the link there. We've got some client video testimonials. You'll see if you click the link, we've split it by industries, for NDIS, consulting, accounting, startup, construction, to name but a few. But there's also a YouTube link there as well where you can view previous webinars we've done on different topics. But you'll see we've actually got 36 client testimonials in there, with people with businesses just like yours using Lawpath to get documentation or advice from our accountants and lawyers. Um, we discuss a whole host of legal and accounting topics, but on today's webinar, of course, we'll be going through who can be a director, the legal criteria for becoming a director within an Australian company, navigating those legal obligations, practical compliance, leverage global talent, including Lawpath's resident director service for seamless compliance. We'll touch base again in terms of how Lawpath can help, and I'll also be running a platform demo at the end. Depending on how much time we have left, it might be a relatively short one, just focusing on some of the key aspects people are, using the platform for. But there will be an email circling around where you can actually book in for a more sort of tailored platform demo. If you want to see, maybe you come to us for the first time, you want to see all the features and benefits of using Lawpath, or if you're already subscribed to Lawpath, maybe get some help on how to tailor documents using the software. Awesome. We'll also be taking questions. Then we'll be taking questions. So please pop them in the Q&A chat box and we'll run through that at the end as well. And I'll also be providing some questions for what you could ask our lawyers and accountants on that demo. But without further ado, I'll hand things over to Damin.
Great, thank you. We do always enjoy the question time. So if you do have questions, drop them in the Q&A. But we'll get straight into it. Lawpath offers what's called a local director or Australian director offering, and a lot of times that's for foreign companies. So where a foreign company is looking to open up a company in Australia, they might not have anyone based in Australia, but they want to tap into the Australian market. So they need a local director to do that. And that's because any company in Australia has to have at least one director, and that one director must at least be an ordinary resident or ordinarily reside in Australia. Now, to be a director, you have to be over 18 years old. You've got to consent to be a director. And if you have one director, it has to be ordinary resident. And if you have more than one director, then you can have a foreign resident as well. So the requirement is just a minimum of one director based in Australia or ordinarily reside in Australia. But you can have more than one and you can have many. Normally, if it's just one director, that's a sole director and secretary of the business. And that's the minimum requirement to have a company. Now, if you look at the details, such as what does ordinarily reside mean, it's not that simple. So I will get into that briefly. But in essence, if you don't have an ordinary resident, then ASIC can prosecute the company. And there are grounds to have the company wound up in situations where it doesn't comply with the minimum requirements. Something else about a director, we now have a new law regarding director IDs. So if you are a director of a company and you haven't obtained your director ID, just Google Lawpath director IDs and there's a guide there on how to get one. You can be fined if you don't. And the purpose of a director ID is that many years ago, people were just incorporating companies potentially with fake directors because the directorship in ASIC wasn't necessarily connected to tax file numbers and things like that to ensure that a company that's being incorporated is actually being incorporated by a real person. And also on top of that, new laws came in place a little while ago where directors are now personally liable for tax obligations, and therefore the whole purpose of the director ID is to minimize fraud so that any director who becomes a director of a company can be connected by their director's ID, which then goes into the MyGov app and generally is connected to your tax file number so that if that company commits fraud on someone, they're able to track down the director and make that person personally liable for those acts. The other reason is to make sure that the director is connected and a real person so that if it doesn't pay its tax, it can go after that person. So ordinarily reside, what is the meaning? It's not the same meaning as permanent residency or citizenship. It's not the same meaning as a tax resident of Australia. It has a unique meaning and it's fairly broad. And the way to decide whether someone ordinarily resides in Australia, they look at various different factors, and it's not a conclusive list. It's just looking at whether there's a connection to Australia. They don't necessarily need to be in Australia at the moment. So there is a situation where someone can be a resident of more than one country because, again, it's not a tax resident. It's just whether they have a connection to Australia. Do they own property here? Are they employed here? How long have they been here? How long are they intending to leave for? Have they left? Things like that. So it's a fairly broad, it's a misunderstanding by many people that it means that you need to be a tax resident or that it means that you have to be a permanent resident. That's not necessarily the case. Um, and so what is the role of a director? What does a director actually do? So the roles and responsibilities of a director are normally set out in a constitution of the company. And if the company doesn't have a constitution, then it's set out in the replaceable rules, which is 135 of the Corporations Act, or just in the Corporations Act generally. But generally speaking, a director is responsible for the day-to-day operations of the company. So they need to make decisions on behalf of the company. They need to be aware of the financial status of the company. They need to engage with their shareholders and get shareholder approvals where required. They have to engage with their other directors and get director approval if and when required. Um, Before they make certain decisions, they got to make sure that those decisions are for the best interests of the company. And there are certain defenses for a director, such as the business judgment rule, where they make a decision, they possibly relied upon an accountant or a lawyer to make that decision, and that decision ultimately wasn't good for the company. If that director can prove that they used business judgment and relied upon advice in making that decision, then there is a general defense for that. But the main thing is that a director can be found personally liable for many different circumstances. So I'll just give you an example of those. And these are ones that fall outside of possibly the Corporations Act or possibly for breach of director duties. So the first one's insolvent trading. So when a company can no longer pay its debts as it comes due, then that company is insolvent. And if that company continues to trade when it knowingly cannot pay its debts, then in those circumstances, the director can be found personally liable from the time the company went insolvent until it actually goes into liquidation or whatever it might be. So during the insolvency period, if the director continues to trade, they can be personally liable for all the debts that are accrued during that time. And that's why companies will sometimes appoint an administrator, because if a company is insolvent, if you appoint an administrator, you can generally save the directors from having to trade insolvent. And that's also why a company will be put into liquidation either voluntarily or by someone else because it's insolvent. Other areas of law where directors can be personally liable, misleading and deceptive conduct under the Australian consumer law. So if the director is the one that's doing the sales, if the director is the one that's approving the publications that might, or the advertising or the marketing material, which might ultimately be misleading or deceptive, then in those circumstances, a director can be personally liable. More recently, you have under the Australian consumer law. And if you don't know where you can find that, it's the Competition and Consumer Act 2010, and it's found in Schedule 2. What we find recently is under Section 24 to 26 of that act, it talks about unjust contract terms. So unjust contract terms is where you have a contract and a clause is unfair. So it's unfair contract terms, sorry. And so in those circumstances, a lot of times we're looking at automatic renewal clauses, fixed term contracts with a early termination fee or a penalty when someone tries to get out of the contract. And if it's a standard form contract, which is used for small business or for consumers who are for domestic household purposes as well, then in those circumstances, you could be found that a clause in itself is an unfair clause. Now, there's also a section of the legislation that can find that a person that's been involved in the enforcement of an unfair contract can also be personally liable. So if you are a director of a company, you have contracts and there's clauses that are clearly unfair. So for instance, you lock someone in for a 1-year contract, they want to get out after 3 months, and you say that's fine, but you have to pay us the remaining 9 months. And then you go and sue them for that. If that clause is found to be unlawful, and if the consumer was to file a defense or a counterclaim, they could potentially bring in the director personally for being involved in the enforcement of an unlawful provision. We also have where a director has possibly made false and misleading testimonials, publications, and we see it quite regularly where directors end up having to give an undertaking to the ACCC, so the Australian Competition and Consumer Act, for being involved in infringements of competition laws or misleading deceptive conduct. You also have, under the Fair Work Act, sections where you can aid and abet an act. So where it's the director who is personally be involved with discrimination or something along those lines. There's something called a general protection, and a general protection is where an employee has a workplace right. They exercise that workplace right, and as a result of exercising that workplace right, an adverse action is taken. So for instance, someone is being bullied at work, they make a complaint, which is the exercise of their right to OH&S, and as a result of making that complaint, the director terminates them. In those circumstances, the company can be found liable, but also the director that made that decision can also be found liable. So there are circumstances where directors can be liable, and then also tax. So non-payment of superannuation, non-payment of withholding employees' tax, corporate tax, GST, and that's pretty much it. So all those circumstances, a company hasn't paid its tax, hasn't paid its employees super or withheld tax on its employees' wages, then the company is liable, but the ATO can issue what's called a director's penalty notice, and that director's penalty notice would then apply that debt to the director personally. So the moral of this story is that if someone says, "Hey, I'm just looking for a director or a director to become to be a director of my company because I don't want to do it because I have a bunch of other companies," you got to be very cautious, because once you take on that roles and responsibilities as a director, you can assume personal liability. And we're seeing this a fair amount at the moment with I saw it in Victoria in the news not too long ago, where a company has essentially put in what we would call a local director. That local director didn't pay attention to the bank accounts of the company, didn't know actually what was doing, and that company was committing fraud on Australians, and they've gone after that director personally for assisting in the facilitation of the fraud and not knowing the financial circumstances of the company. Now, the general duties of a director is to be honest and careful in all your duties, pay your debts on time, keep proper financial records of the company, act in the best interests of the company and in the best interests of the shareholders as a whole, and not to misuse the information or documents that you have for the benefit of yourself or someone else. Now, when we look at the actual documents that you need to keep, you need, for tax purposes and under the Corporations Act, you have to keep all financial records for a period of 7 years. It's not just for tax, it's also for shareholders to be able to gain access to the books and records of the company to investigate what's been going on with the company. And generally speaking, where you have 5% shareholding of the company, or where you have a group of shareholders who have 5% shareholding in the company, they can request access to the books and records of the company for a proper purpose, and so long it's in good faith. And if the directors or the company refuse to give access, they can make an application to the Supreme Court to get access to the books and records, including the financial reports of the company. And if they find that those financial reports haven't been properly recorded, well, then that will be a breach of director duties, and that could warrant the removal of a director. So those are some of the important aspects of keeping proper records, which means that when you have consents from directors to come in, you should have those signed. When you issue shares to someone, you should have share certificates. You should have a share register. You need to update ASIC on any issuance or transfer of shares. You need a register, which is effectively an Excel spreadsheet showing who holds what shares. You should have a constitution. If you have more than one shareholder, you should also have a shareholders agreement. And we've done a lot of videos on shareholder agreements generally. So if you want to have a look at our YouTube channel, you'll see a bunch more webinars on different topics, as well as webinars on specific topics such as shareholders agreements, founders' rights, preference shares, things like that. Now, the general duties are all spelled out in the Corporations Act. So we have the duty of care and diligence, good faith, not to improperly use your position, use the information, insolvent trading, material personal interests, books, proper books. And then we also have other areas that are just in case law, which we call fiduciary duties or common law duties or equitable duties. And those are the duties of fidelity, the duty of good faith. And those duties extend beyond your role as a director. So a lot of these are while you are a director, but the fiduciary duties go on past your time as a director. And the most common situation we see these breach of director duties are where a director has not disclosed a personal interest, so they've entered into a transaction, but they're actually receiving a secret profit somehow, or where a director resigns and then goes out and starts up a competitive company the next day and takes all the clients and employees and intellectual property and so on. That would be a breach of the director duties because they're misusing the client list, which is the information and the documents. They're improperly using their position to have had all those connections with all those customers and then pulling them across to a new company. So those are just some things to have consideration if you are a director and you're looking to go and start a new company that's in direct competition to your company that you're a director of. A couple examples of cases. So this case lays out in a good organized manner of how you can breach it and what is not a breach. So if you look at Section 180 of the Corporations Act, it talks about the business judgment rule. So you have to act in good faith and the best interest for the proper purpose of the company, and not gain advantage for yourself. However, as long as you use business judgment or if you disclosed a personal interest, then generally there are exceptions to the rules. This case talks about the abuse of power. So where you've taken advantage of your position to gain a secret profit, again, it's not allowed. So if you're getting a kickback from someone, or if you're entering into a contract with your spouse or family member, and you're not disclosing that, or if you're entering into a contract with a related company of yours. So for instance, you create a joint venture with another company, and then your company is being contracted to that company. There has to be disclosure. Even though it's obvious, you still have to have that disclosure, and you're generally not allowed to vote at a resolution of the meeting where it's agreed that you're going to enter into that contract. These are some other cases about improperly using your position to gain advantage. And we just talk about some of the cases here so you can have a read of them. This webinar will be online. So if you want to have a more clear read of these sections and these cases, you can do so on the webinar when it's uploaded to our YouTube channel. And again, just some more cases talking about misuse of confidentiality, confidential obligations, and that being an improper use. And then finally, what can you do? So let's say a director was to breach their director duties, then you as a shareholder, you can bring an action in court, which is called a derivative action. So a derivative action occurs where you're never going to be able to get the court to sue a director because the directors are the ones that make the decision, or you're never going to get the company to sue the directors because it's the directors that make the decisions for the company. So as a shareholder, possibly a minority shareholder, you can apply to the court and say, I want the company to sue this director and have this director removed. And by doing that, you bring what's called a derivative action under Section 136 or 137 of the Corporations Act. And then You can also seek various orders. So where a shareholder has been treated differently to others, like oppressive conduct, or where they've been unfairly prejudiced or discriminated against, in those grounds, then there are sections of the legislation that can undo certain transactions. So for instance, if the company issues a lot of shares but didn't give you an opportunity to buy those shares, well, under the Corporations Act, there's a first right of refusal. And also, and if you have a shareholders agreement, there's also normally a first right of refusal to buy those shares. So if you weren't given an option to buy those shares, then there might be a opportunity to have those shares canceled, or to give you the opportunity to buy those shares before they go to somebody else, or to undo certain transactions. And Section 33 gives a wide powers to the court to transfer shares, appoint, remove directors, wind up the company, force the sale of the company, force the sale of shares, correct the register of it. So say someone's taken shares away from you without your approval, and then you can seek damages against the company, and you can seek damages against the directors of the company. So I'll pass it back over to Connor, and if you have any questions, pop them in the Q&A now.
Easy. Thanks, Damon. So we'll quickly just go a bit more into obviously how Lawpath can help. Then we'll break to Q&A, and finally a quick platform demo, depending on time. So please pop in your questions if you have any questions on the content we've just shared, or anything else that's kind of springing to mind as you're, maybe about to start a business or have started a business. But first off, you just go to the next slide, Damon. Probably best just to showcase everything on the platform. Thank you. Awesome. So we're very much a one-stop shop, and this doesn't even include everything in there with this screenshot here. But we do your registrations, your asset compliance. We have a virtual office there as well, which is really popular with people who have home-based business, just to hide their home address from people who research it, but also provides a bit more of a professional company address for their business. But our bread and butter outside of everything else here is very much our advice plan and tax plan. So the Lawpath Legal Advice, for example, it offers a variety of legal services and tools to help your business manage your legal needs efficiently and, importantly, very cost effectively. Our clients are all, as I mentioned earlier, small businesses looking to fulfill their legal or tax obligations without it breaking the bank. So we're tailor-made for startups. So if you do need quick access to documents and a fast turnaround for your legal advice, that would be the right fit for you. It includes a document builder, the fully customizable documents, and we also have a Lawpath AI built into there, which we've actually partnered and built in collaboration with Amazon AWS services. But in terms of actually the nitty-gritty of what's included, if you just want to go to the next slide, Damon, I think it'll be the legal plans there. Yep, so you have the essentials and then the legal advice, which most people are on, or they might start on the essentials and then just naturally upgrade to the legal advice to get, for example, unlimited on-call legal contract reviews, unlimited 30-minute phone consultations with our experienced lawyers, and you can also get additional discounted fixed price quotes for any additional legal work that you may need to do, like contract drafting or trademarking, whatever it may be. Obviously, this kind of removes a lot of the expensive costs of consultations, the expense of contract drafting, where lawyers will typically bill, thousands of dollars for when you're setting up your company, but you can still protect your business, and it does not have to cost you an arm and a leg. These are same day or next working day bookings, and you can discuss, which I'll show later, a variety of different legal matters, such as your business structuring, your legal obligations as director, intellectual property, debt recovery, startup law, employment and HR, which is really popular, and commercial property as well. And if we just go to the next slide, Damon, because we do also, as I mentioned, provide accounting and tax services as well. Oh, I think you might have the wrong slides, Damon, but no dramas. We also have the Lawpath Tax and Advisory. So that offers a suite of tax and accounting services tailored to meet obviously the needs of your business. It's designed to kind of help you manage the financial compliance and also optimize your tax strategies for each financial year. Which is what a lot of people come to for advice on that, is tax minimization, tax planning, as well as advice on specific types of tax, accounting software queries, trust advice. There's a whole host of things, which I'll show you guys later when we go to look at booking a consultation. If you would like to hear more about that in a bit more depth, then the email circling around does have a link where you can book in a call if you do have questions specific to your business or just want to suss out if Lawpath's the right fit for you. And it also has a link as well to book in a demo there as well. We've got here on the page our new bundles. So we will be promoting a discount for our standalone plans, which is 30% off on our legal advice, accounting advice, and tax compliance, which will end tomorrow. However, we do have bundles, which is always our highest discount when you add plans in together. So you could have legal advice with accounting, you go legal and tax, or accounting on tax, depending on your preference. These are always with 40% off if you opt in for any of these. So we'll move into Q&A now. You can actually ignore this coupon here, as we actually have a higher discount currently. So if anyone would actually like to get the 30% off, just shoot me back an email or say yes in the chat, and I'll try to reach out to you guys directly.